Please be advised that this podcast was made for fun and to share the general experiences of two criminal lawyers in Toronto. You must not take anything you hear in this episode as legal advice. Every situation for every person is different, and you should always consult with a lawyer for legal advice specific to you and your circumstances.
Well, welcome everyone to our latest episode of Justice Redefined, the podcast brought to you by Titan Defence LLP. I'm Kabir Sharma, criminal defense lawyer and partner at Titan Defence LLP, and I'm joined by
Sina Shabestary.
What do you do here, Sina?
That's a good question. I'm not sure on many days, but apparently I have proclaimed myself as a partner at Titan Defence LLP.
Well, there's only two of us, so I mean...
And it's the only way either of us would have ever made partner.
So how's your weekend, man?
Pretty good. Had a pretty chill weekend.
How's the new house?
Good. Getting settled in slowly.
Nice, man. I'm happy to hear that.
How about you?
Not bad, man. I went to the gym a couple times. I'm getting ready to go on my trip soon.
Oh, nice.
So gotta lean out a little bit. You know?
Getting deezed?
Getting deezed, yeah. As much as deezed you can get in 2 weeks.
Excellent.
So today's episode is an episode that is kind of, the topic transcends all elements and all aspects of criminal law, and that is disclosure. So briefly, in a nutshell, disclosure is what the defense kind of relies on when preparing for a case. So typically, what do you find that typically disclosure is useful for on your end? I know obviously it's for preparing and defending a case, but what kind of things do you look for in a disclosure package when you receive it?
So first and foremost, disclosure is effectively the word that we use in the criminal justice system for the evidence that the police have gathered through their investigation, which they then give to the Crown, which the Crown then uses in order to prosecute any given case. And they have an obligation to disclose the evidence they intend to rely on in a case so that the person, as you said, can make what we call full answer in defense. And this seems to be something that's very simple and straightforward, but it's in fact quite a complex issue in criminal law. And
you go ahead.
And I think we're of a relatively newer vintage, and speaking to older lawyers, they oftentimes talk about times when the first time they would figure out what the case was about was when they rocked up to the trial the morning of. So, the seminal case, obviously, as we know, is called Stinchcombe. Stinchcombe is not really that old, and it's what forces the Crown to effectively disclose the evidence that they intend to rely on. What do I look for? I think disclosure is something that happens very gradually. And oftentimes when people come to me at the beginning stages of their case, they're like, what do you think, etc. And what I always say is a phrase that I learned from one of my mentors, which is like, I'm shadowboxing here.
Yeah.
In other words, the only information that I have to rely on at this moment is what you're telling me. And unfortunately, as much as, that's important, what is more important at the preliminary stage of the proceedings is what's in the disclosure. And what I like to tell people is it's not what you know, is what you can prove. So let's see what the police officer said. Let's see what the alleged victim or the complainant said, etc. And so, going back to the gradual thing, is initial disclosure, as we know, is something very different than what could end up down the road. It's something that we get, we look through it, we decipher what we need further, and we start to request and ask for disclosure. And what I look for is very different depending on the charge and the
type of case.
Exactly,
right?
that I'm working on.
Because disclosure, I feel you usually get it. You're supposed to get it pretty early on, like on your first appearance. So nowadays they give you disclosure on like an online disclosure hub. I remember before you used to get it like in paper or on disc, and it would be crazy. Like even like before COVID, you'd be requesting disclosure. So you have like a murder file, and there'd be like 4,000 paper pieces of disclosure that you'd be getting in fucking like banker's boxes.
Basically, yeah.
And you'd have to sort through. Not organized well or anything like that. So like Sina said, yeah, I guess you do get it on You get like the initial disclosure early on, which kind of gives you an idea of, guess, like what to look for and what to request, because it, like the way I try to explain disclosure to clients, because it's kind of a technical term, I like to say it's basically a copy of the police file. So you get a copy of the police file, most of it.
Right.
Right. There's some stuff obviously they keep for themselves that they don't give to you, which is considered their like work privilege stuff or whatever.
Right.
But, you know, like you get like statements from any witnesses, whether they're video or written, right? You get like video surveillance, you get police officers' notes, you know, you get a whole bunch of standard things. And like Sina said, after a while, you begin to figure out what kind of stuff you need to request based on the type of case.
Yeah. So, other elements of disclosure, for example, if there's a complainant who makes a 911 call, that would be disclosure. Obviously, if you're talking about a project case or a case where there's intercepts, those wire intercepts are going to be provided as disclosure. And so I think the two things to keep in mind about disclosure and what you can expect in your case is a determination that's going to be made by the Crown, sometimes on their own and sometimes at the defense request. And those determinations boil down effectively to, is the disclosure relevant? Is what you're asking for going to be relevant in this case? And secondly, do they have it? Is it in their possession? Right?
Yeah.
And if it's not, it's something that requires an application to be brought, like a third-party records application, which could include medical records and things of that nature.
But sometimes I find that there are things that are obviously like relevant that are not included, right? For example, when there's like a domestic assault or one of these kind of charges that your client's facing, I feel like you always have to request the criminal record of the complainant.
Yes.
They don't just give that to you.
Right.
Right? And what they say is, oh, I give you whatever I have. So basically, sometimes I feel like the police are selective in providing to the Crown Attorney what they have. They only provide basically the bare minimum that's required to prosecute someone.
For sure.
They're not giving you disclosure that helps you to defend yourself. Right? And I think one of the most important parts of being a lawyer, especially a criminal defense lawyer, and it comes over years and years of reviewing disclosure, you begin to, and running a lot of trials, you begin to see that there are certain things that you're entitled to that are relevant that you wouldn't otherwise know until you need them at that time.
For sure.
Right? So, for example, in a lot of drug cases, when there are police cruisers that are together conducting surveillance on a particular party, say they're watching a drug dealer or something like that, or a person of interest, they used to communicate with each other through their, like, they have a messaging system between the laptops in the cars, and it's like an instant messaging system. So all the police cars, they'd all be communicating with one another using something called a mobile data terminal, which is like their computer system. And so you would ask them for this material all the time, and it would never be provided to you until eventually, in my case, the Crown needed it for something. And all of a sudden, those records were produced to me. And then I was like, you know what? This is like pretty relevant stuff. So I started requesting it all the time. And I feel like a lot of defense lawyers started requesting it. And then the police stopped using it. And now they talk on cell phones with each other. And there's no way you can get cell phone recordings, because if they communicate on the radio with each other, you could order radio communications because all that's recorded.
Right.
Right. And I'll tell you a story about radio communications that I ordered. I was representing, it was a guy and a girl. Both of them were black. They were driving north in the 400s, somewhere in like Aurelia or something like that. And they got pulled over for speeding. And the police searched the car and found fentanyl in the car. So I went and requested, and it was a really shady pullover to begin with. So I requested radio communications. And when I get the radio communications, half of them are bleeped out. So the entire part where and all I see at one point of the radio communications is, it's those people again, we're going to get them. And I was like, what? I'm like, this sounds a bit shady to me. So I'm like, I need transcripts of the radio communications. I get the transcripts of the radio communications, half of it's redacted. The entire part where the police officer is speaking with the dispatch to explain what he's doing at that time, all of that is redacted.
Yeah.
So I'm like, there's something definitely shady going on here. And it's part of the Crown's disclosure obligation, not only to provide the radio communications, but complete radio communications.
Yeah.
What are you hiding, right? Was
Yeah.
my question. So we're going to get into this a bit later, but I had to bring an application to unredact the material. And the second I said I was going to bring that application, they just ended up dropping all the charges against my client.
Well, yeah, that's a fantastic result. Or sometimes even they'll say, no, it's not relevant, or we don't have it, or you're not entitled to it. And then you're like, okay. And you bring the application, and the morning of the application, they just either disclose it, or worse yet for them, they drop the charges.
Yeah, I'm convinced that it was some racist shit that they were talking about.
For sure. And that
Right?
happened in one of my cases too, actually. And it was a very relevant and initial disclosure, which was basically an officer who transported my client after they found a gun in the car in which he was in, was sitting in the Sally Port. And the Sally Port, for the listeners, is where the police cruisers pull into the police station before they take the person to get paraded and do all the things that they need to do once they arrest them. And I just sat there listening to this video entire way through, and this officer, who really had nothing to do with the investigation of this case, but had just heard secondhand information about what the investigation was about, makes a personal phone call to another officer and starts talking about this case and what he's currently doing. And he talks about my client and how the police just went up on him without having a source of information, basically randomly.
Yeah.
And then they were able to produce this firearm, and how he thought that was so crazy that the investigation did that, and then went ahead and told the other officer where my client was from. And he was from Toronto Community Housing. So there was just this really dirty cultural insinuation of, we got another black guy from the ghetto with a gun that had no sourced information about it, right?
Yeah.
And I used that at
Look
trial.
at these people.
And I could see the trial judge just cringe as I played this part of the video, and asked the officer that was on the stand that the transport officer was speaking to about it. And he effectively perjured himself, because he was like, no, I never spoke to him. I never said anything about the case to him.
Let me guess. Then he said, oh, I forgot I spoke with him.
Basically,
Yeah.
of course.
Oh, sorry. Honest mistake. I forgot that I was saying all these racist things. Because how often do you say things like that?
Exactly. So, you know,
it's like
going back to your point, of course, I think what is the starting presumption, and this is what's intuitive to everyone, is that the Crown's function is a truth-seeking one. In other words, they shouldn't really be after securing convictions. They should be after getting to the bottom of the truth. What happened here?
including persons' rights, ensuring that people's rights are maintained and not violated.
100%.
Right?
So, and that would include pieces of evidence or disclosure that would hinder their case, that would be bad for their case. But as you said, I think a mark of a great lawyer is to look further and to request things. I mean, what's the worst thing that could happen? They say no. And if you really have a leg to stand on, you bring an application before a judge and you litigate the issue.
Yeah.
Right? And to that point, there's a lot of stuff that's absolutely and totally relevant disclosure that they don't disclose. One thing you've already mentioned, a victim or a complainant's criminal record, it's absolutely relevant, and they don't provide it voluntarily, and it's something you have to ask for. Why? That person is undoubtedly going to have to testify for the Crown to prove their case.
Yes.
And during their testimony, you're absolutely entitled to put their criminal record and all of their previous wrongdoings to them. And lo and behold, they might eat it. They might be like, yeah, I did this. This was wrong. And that would bolster their credibility.
Of course.
But they still try to hide that shit. Another one that really kind of irks me is McNeil reports. Time and time again.
Yeah. Well, first, what's a McNeil report? Maybe we should ask.
So a McNeil report is what it refers to police misconduct. It's a report of a police misconduct, whether there was criminal misconduct or not. It's an internal disciplinarian body that they have that deals with police conducts. So what you get in disclosure more often than not are the police officers' names that are involved in a case listed, and it'll say McNeil, and it's just a box ticked yes or no. And that's all you get, right? I'm like, okay, that's great. This officer had a misconduct. What is it?
Yeah.
Exactly. And, you know, again, I say that's a mark of a good lawyer, because a lot of defense lawyers are shocked that I have an individual that she's lovely too. She's so nice.
Yeah.
I just email her. I say, this is the police officer's name. this is their badge number, and this is the date and time of what I believe their misconduct to be. And if there is anything within their internal system, she discloses it
They
to
have
me
to.
because they have to.
And then the Crown won't give it to you.
Right.
And the police won't give it to you. But then that police head office is obligated to give it to you, and you get it.
But this is the thing.
That's bullshit.
It is bullshit, but I love it. And here's why I love it. Because if you get it independent of them,
Yeah.
they didn't disclose it to you, they have no idea you have it.
Yeah,
And then
slap
you
them
can
with
just
it.
destroy, like in the middle of
Yeah.
it. And it doesn't even matter. Of course it's relevant. Of course, even if it has nothing to do with the case, even if a misconduct was something as obscure as a theft, an allegation of a theft, which is something I've had before.
Yeah,
right?
dude, it's fucking dishonesty, man.
Exactly. And they're in a
Yeah.
position of trust, and they're in the public sector. So absolutely that's relevant. And so the way that you slap them with it is put it to them. Do you have any misconducts? Have you ever?
You would never steal anything, would you,
Exactly.
officer?
You've never committed a crime of dishonesty, have you? Invariably, they're going
You've
to say
never been
no.
charged, officer. have you?
Exactly. And then lo and behold, here you have it.
Yeah.
Right.
And there you go. And so that's like that. See, that's one of the most important things is being competent and smart enough and having the knowledge of requesting the right things.
I want to say one other thing.
Yeah, go ahead.
Aside from you're talking about requesting the right thing, you're talking about what? I think equally as important that's lost on a lot of lawyers is when.
That's true too.
You know?
I think I have a good story about that.
Yeah.
And after you're done, I'll tell you.
I think
I'll tell
like
you about it.
first of all, in terms of initial disclosure, I never ever wait for the first appearance.
Yeah.
Because you always want to maintain a track record of you consistently asking for disclosure so that when there is a delay in giving it to you or you're not getting it, the court is going to be pissed off. They're going to say, why this was relevant. Now you're giving it to them. You've delayed this entire process, which could absolutely go to an issue of delay, which I'm sure we'll talk about later.
Yeah.
So what's the
So
story?
listen, this is a crazy story. I heard this from a lawyer. His name is Gary Grill. He is an OG lawyer. He's super skilled, one of the best.
Legend.
And he told this story about one time where he had this cop. It was like a drug case. His client was black. And he had this cop at the preliminary hearing. This cop testified like an angel. And Gary felt like there was some kind of racist shit going on, but he couldn't prove it. And his client kept saying, "Yo, this guy's a piece of shit. This guy's a piece of shit." But he came off looking like the absolute biggest angel that has ever come before the
because
court.
they're professional witnesses.
Yeah, they're professional
That's what they do for a
witnesses.
living is they testify.
And he comes off, and Gary's thinking to himself, "Man, am I the asshole here? This guy seems he's great." And then they're still requesting disclosure. Like for some of these big cases, like some disclosure you end up getting later on. Sometimes you can't wait for disclosure. Sometimes you're supposed to look at all of it. But he said that he was looking at the booking video because every time someone is getting booked, like when they get arrested, they get brought before a sergeant. They get asked a series of questions. You have mental health problems.
Yeah.
How much money you have on you.
You're intoxicated.
These are your rights.
Yeah.
Or you're intoxicated. And it's all on video.
Yeah.
And the officer's there. And it's like their way to formally advise someone that they're currently being arrested and they're going to be housed in a cell. So the last 15, the prelim's already happened, okay? They're looking at this after the prelim. So he's already made all these, I'm not racist, I have black fucking foster kids or whatever he was saying, right? He was saying crazy shit like that, right?
Okay.
And then at the end of the booking video, it's the last 20 seconds before it cuts off. He looks toward that same cop looks towards Gary Groves, his client, and says, "So how many baby mothers do you have?" And it was caught on video. And they saw this and they were like, "Yo, I knew this guy was a fucking piece of shit and I couldn't find him." And they fucking slapped him. The Crown saw that. And after the Crown was like, "Man, I don't know what to do." Because that's overtly stereotypical and
Absolutely.
that's something that you wouldn't expect a police
For
officer
sure.
to say. So now what he does is sometimes he requests these things after the prelim.
Yeah.
To not even alert the police or the Crown that something may be happening. Get them to commit to a story first.
Yeah.
And then get the video so they can't change their story for the prelim because they've already gave their evidence under oath. So I've started doing that a lot now too. And also certain things like requesting certain types of video footage, right? Like, if I get certain video footage, that's great, but I'm not going to go crazy requesting something that may incriminate my client either.
Yeah.
Right? And you got to be important. And at the end of the day, it's important to be fair and honest, but I play by the rules of the system. The rules of the system are you got to prove your case beyond a reasonable doubt.
For sure.
I'm not trying to help you in any way by alerting you to there being videos that you haven't disclosed or anything like that. If you're being lazy or you don't know that this happens or you're being careless, that's on you. It's a part of the system. The system has failed because you didn't do your job diligently.
In fact, but for one circumstance under which you should and have to, you don't have any obligation of triggering an investigation for the Crown.
Yeah,
right?
Not at all.
And what is that one circumstance?
It's an alibi defense.
Alibi defense.
Yeah.
That's it. If
That's
you
the
have
only
an
time.
alibi defense, you have to allow the police early on enough to investigate that defense. Otherwise, you don't have any obligation to do that.
So, you have certain different types of cases, and those different types of cases require different types of disclosure requests, right? 911 calls are automatically nowadays kind of requested, right?
But not automatically provided.
Not automatically provided, no.
Even though they are a lot of times the cusp of the case, right?
Yeah.
And for the longest time, this may still be the case, the Crown wouldn't disclose 911 calls until the matter was set down for trial.
Yeah.
Which is kind of absurd.
Yeah, and then you'd get you set your matter down for trial, and you would hear your client yelling, "I'm gonna kill you," to the complainant on the phone.
Exactly.
And then it's if I would have had this earlier, I probably wouldn't have set a trial date for this guy.
Yeah.
Maybe not. I don't know. It would have changed my defense a little bit, right?
Yeah. Or maybe you would have resolved, and now the Crown's resolution offer is off the table because their deadline was in advance of setting the matter down for trial.
If you set it down for trial, we're gonna ask for jail. But if you do it before trial, then we're gonna give you no jail or some shit like that. So, an assault case, domestic assault cases and assault cases, you always want the criminal record of the person that made the complaint, criminal records of all the witnesses. And recently there's a case that came out from the Court of Appeal, R versus Pascal, where the Crown has an active obligation to advise you of outstanding charges or criminal records for any potential Crown witnesses or any complainants on their own. Initially when that case first came out, I was getting emails from Crowns saying, "Here's Pascal disclosure."
Yeah.
With the list of all the witnesses and whether they had records or outstandings or not.
Yeah.
Where the shit did that go now, man? I don't get that anymore.
Yeah.
Now I asked for it again and they're like, "Oh, nope, sorry, you don't get it. You have to file some kind of an application." And for some cases, sometimes it's important for me to know if the person that I'm defending, the complainant in that case, is someone that likes to call the police all the time for no reason, or likes to make a lot of false claims.
Yep.
Right.
Yep.
And there are many cases where people use the police and the justice system as a weapon to coerce someone to comply to their demands.
Right.
Right.
Yeah.
This happens often in domestic cases.
Yep.
This happens often in sex assault cases. And in those situations, there are something called occurrence reports that are sometimes also very important.
So what is an occurrence report?
An occurrence report is it's a report where somebody had any interaction with a police officer, whether it led to charges or not. So if someone called the police on someone and the police came, investigated, and said this was bullshit, that's an occurrence report.
Okay.
Right? If somebody was a witness for something and they spoke to the police, that's an occurrence report. So some of these are obviously more relevant than others. I don't give a shit if someone called the police because their neighbor was cutting their lawn or something like that. I don't give a shit about that.
Yeah, of course.
With respect to occurrence reports, it's important to sometimes you get these kind of occurrence reports. The Crown sometimes, at one time I've had a Crown say to me that they're relevant because they involve my client. So I got them. But other times you have to sometimes they'll say no and you have to engage in other ways to get them, i.e. bringing an application before a judge.
Right. And that makes a big difference, because I think a lot of times crimes will be like, no. Sometimes because they've got a heavy caseload, they don't want to be looking through other disclosure, go down every rabbit hole. They think it's a fishing expedition, whatever the case may be. And then you force their hand by bringing it before a judge who will make that determination. And then, the relevance will become important. And I think that's also a mark of a good lawyer, is that you should be live to all of these issues. You should ask for things. You should maintain your position and be aggressive, and not be like, well, okay, you don't think it's relevant and therefore I don't have it. I don't have it. Yeah, exactly. And sometimes, things might arise mid-trial and you could just ask for it then. You can't proceed not knowing what you don't know.
Exactly.
Right?
I have another story about another disclosure request that I made, thinking I was like, I was kind of young. This is like a couple of years ago. And I heard the story about Kim Schofield requesting the radio communications the morning of the trial.
Mm-hmm.
So the cops didn't know that they were going to be confronted
Right.
by these radio communications.
Yeah. Scrambling at that point.
Yeah. So what happened was they all gave evidence. They all gathered together. I'm sure they all gathered together. They all came up with a story, and they all gave the same story to the judge. And then you listen to the radio communications, and that's not at all what was going on at that time.
Yeah.
If she would have requested that disclosure earlier on, those cops would have changed their story to ensure that it was consistent with the radio communications.
Right.
So I learned something important. I'm like, if you're planning to ambush the police or your witnesses, which you can do in some cases, you can't in other cases, try to request disclosure late. So what I did was I was representing a guy one time where the police used a special kind of breaching shotgun to blow a hole into his door to get access to his house, to search for a gun, while he was under arrest outside of the house and had been tased twice, and they already had the gun. So I'm like, dude, why the fuck you blowing this guy's door open with a shotgun when he's already under arrest, like outside?
Yeah.
And man, it was dangerous. It looked like they kept saying, oh, it was safe, we have a lot of training, all this kind of shit.
Right.
But I wanted to know, I've never heard of this thing, so I'm like, I'm going to file a charter application with respect to them using this device, this shotgun, because if there's a little kid standing on the other side of that
For
door,
sure.
it's not like a battering ram, dude.
Yeah.
That person's getting shot.
Yeah.
For sure, right?
So wasn't there like significant damage to an interior wall inside the house from them breaching the door?
Yeah, there was holes in the wall. There was holes in the stairs. Like there was wood everywhere.
Yeah.
Just totally like,
Yeah.
it didn't look like it was anything more than a regular shotgun.
Yeah.
I questioned the cop. I'm like, hey, man, like, would you want to stand on the other side of that door? He's like, no way.
Yeah, of course.
Like, obviously, it's dangerous. But what I wanted to do was, if I would have requested it too early, I thought maybe they would have, like, figured out what I was doing. So I show up to the morning of the trial, and I'm like, I have a disclosure request to make. And the judge is like, what?
Yeah.
And I requested all of the use of force for Pure Regional Police, all their training manuals, everything that they look at, all of the rules and regulations and procedures. And these officers are not regular police. They're like the SWAT team of like Pure Regional Police. They're called the Tactical and Rescue Team.
Yeah.
And they have one's like as a sniper, one guy's like aircraft hijacking expert. These are like good fucking cops, right? And so I got there and the judge obviously was fucking really pissed at me because she's like, you should have requested this much earlier.
Fair enough.
Right? But I figured if I requested it earlier, it would have made a difference in my case. But I realized for a case like that, it doesn't make a difference whether you request it earlier or not. It's just a bit of trying to be a bit too fancy, I guess. When you're young, you learn, right? But that's another item of disclosure that would not be relevant in any other case. It's not even necessarily relevant in that case. It's only relevant because I brought an application for a stay of proceedings because of the use of that shotgun. Yeah. Otherwise, it would not have been relevant, right? So you need to be aware of the right situation in which to also request certain disclosure in addition to the right time and the right case.
For sure. I think policy matters. and you need to, especially when you're alleging charter violations of your client. The reason why policy matters is because issues that you can show are systemic, or in other words, show a pattern of conduct on behalf of the police, bolster your argument, because then you're not just saying, hey, my client's rights were breached. You're saying to the court, the judge, to vis-a-vis the judge, to the court, that if you don't do something about this, if you don't send a message out to the police in the way that they've conducted themselves, this is going to happen again and again and again because of that pattern of conduct, right? And that's something that the courts do take very seriously. An example that I had, and I had to chase so many rabbit holes. Like, this trial just blew out of proportion, which was, this trial was extended far beyond what our estimate was. And so it kept needing more days and more days. And in the middle of this trial, I varied my client's bail so that he was no longer under a house arrest condition. In between some of the trial dates, he ends up leaving Toronto, and he goes to Thunder Bay, and he's erroneously arrested in Thunder Bay in violation of his bail. And I had to subpoena a bunch of police records, and I contacted the police in Thunder Bay. I said, listen, you're wrong. I don't know what you're talking about. He doesn't have a house arrest. He's no longer on that. They're like, well, sorry, counsel, we can't go on your word, but this is the information that we see in our system. Even when I sent them the documents which proved the bail variation, they still had to do their due diligence, keep my client, and wait to hear from the Crown in Toronto here.
I don't blame them for, because,
Sure. Any counsel, but it would be very serious. They're officers, fine, but they need to also recognize us as officers of the court.
Yeah,
which means
that's true
that
too.
I'm never going to, ruin my reputation.
Forge a bail variation to get
exactly.
your client off of a fucking arrest in Thunder Bay.
So the level of disclosure that I had to request and the applications that I had to bring to get why this happened, what was this delay, basically brought about a very real systemic issue where I even had civilian police witnesses subpoenaed to court to talk about the process that happens between a judge or a JP signing off on a variation and that information ending up in the police system, right?
Yeah.
And it became abundantly clear that it's a problem. It takes time, and it's very much prone to mistakes. And even to the point where their system only allows a certain number of lines for what the conditions of bail are, such that when an officer in his police cruiser, for example, is looking up the conditions of the bail, it's up to them to look further to see what the conditions are.
Like, it doesn't pop up.
No. So what happens is their department what they need to do, or what they're, I guess, trained to do, is to prioritize the conditions, because they're limited in the number of entries that they can see at a first glance. So they're trained to put the most important conditions up top to prioritize it. And in this instance, this hadn't happened, right?
I see.
So to just, thousands of pages of disclosure, days of litigation, just to prove this is a systemic issue, because, and why shouldn't it be? Lo and behold, my client was erroneously arrested. He had to remain in jail. Even when I brought this to their attention, the Crown in Thunder Bay agreed to release him. They weren't going to release him previously. They were going to keep him.
Yeah.
And even when they did, they released him on a banishment clause. Basically, they're like, get the fuck out of Thunder Bay.
And never come back.
Never come back here, right? So long as you're on this bail, don't come back here, right? That's serious issue on someone's liberty, like geographical liberty, being remained in custody, all of that. So, that obviously played a factor. There were a ton of other issues in this case, but that was a factor. And I think the point is that you need, when it comes to disclosure, despite how far we've come as defense counsel in regards to us even being entitled to disclosure now, you need to be a pit bull about it.
Yeah,
You
do.
gotta
You gotta stay
ask.
consistent about requesting it too.
Absolutely.
You know, because what the court sometimes does is say that you're requesting this disclosure, and you don't get it, and then you show up the morning of and you start making us think about how you don't have it. The judge is gonna go to you, well, Mr. Sharma, how diligent were you in requesting this
Absolutely.
disclosure, right?
Yeah.
You just requested it once, and you just stop talking about it entirely. That's
Yeah.
not how it works, right?
Yeah.
And they're kind of right about that. You should be like actually being as diligent as possible. If it's that important to you, then you should be doing that.
Well, I mean,
right? So,
that's the instance under which I think you fall on the sword for your client. You say, you're right, Your Honor. I might have not been diligent in requesting this, but if in so many words, my mistake, or worse yet, my incompetence, shouldn't punish my client.
Yeah.
And really, the remedy there is, if there's an adjournment, if you need more time, whatever,
come
sure.
back tomorrow, whatever it may be, right? And sometimes that you come upon a situation where there is disclosure that should have been available, but no one cared enough to secure that disclosure,
Right.
and then provide it. For example, there are some Toronto Police Service cameras in certain quote unquote high risk parts of the city.
Right. Red zones.
Yeah, red zone, what they call them. These are TPS cameras that are monitored by people in like a command center and like all this other kind of shit, right?
Yeah.
And they lobby to have these cameras put. And what you'll see happens is that oftentimes the only time you get footage from those cameras is when your client has done something incriminating.
Yeah.
When it's to exonerate your client, no one bothers seizing it. So, for example, I had a case one time where there was a brawl that happened outside of a club. I think it was Tris nightclub or something like that back in the day when that was still around.
Nice.
And yeah, surprise, surprise, a brawl happening outside of there. And this one guy gets into a fight with another dude. I think one of the guys was black, one of the guys was Asian. And then my client is a black guy. He's just standing around there. And he doesn't do anything. And the police think he's the black guy that got into the fight. So then they tackle this guy to the ground. They tase him. They beat him up. They arrest him, charge him with assaulting police, all this other kind of shit. And so this was right where the camera was for the Toronto Police Service.
Did they sprinkle some crack on him too?
Yeah, I'm sure that was the next step. Oh, sir, there's also a gun in your pocket.
Yeah.
And I think he was charged with disarmed police officer too.
Jeez.
And so I request this disclosure of this video, right? We don't have it. We didn't save it.
Yeah.
You didn't save it. There was a criminal offense that occurred. Your police officers were apparently assaulted, as according to what they say.
Yep.
Shouldn't you have saved that? No, not at all. So in that case, when they're so, this is the word I describe this conduct all the time. It's called unacceptable negligence.
Yeah.
When you're so negligent, where it's literally that video is a phone call away from you securing, and you don't do that,
Yeah.
and that could add to the case,
Yeah.
then I bring something called a lost evidence application.
Yeah.
Right?
Yeah.
So this is disclosure that I was entitled to. No one took any effort to try to secure something that's so important.
Right.
Not to my client. It's important to the Crown too.
It's important to the truth.
Yeah.
What happened?
What happened that
Yeah.
day? And it's fucking video footage, man.
Exactly.
And that wasn't saved. And then lo and behold, go to court, cross-examining this cop. He fucking doesn't remember anything about that night. There were so many fights outside of there.
What a shocker.
He was just didn't remember shit. And that made that video even more relevant.
Exactly. And that's when, during a cross-examination of a police officer in that circumstance, what I love putting to them to just bolster the lost evidence application is, tell me, do you know what the best evidence rule is? Right? And they always say yes, they have to. They're police officers. Yeah. What is it? Isn't it that you have to preserve the evidence that would best explain the offense for which you're doing this investigation?
Yeah.
Right? Yes, it has to be. Is there better evidence than video surveillance?
Yeah.
Doesn't video tell the truth? Isn't your function to investigate the truth? right?
To find out what happened here.
Exactly.
That's an investigation.
Exactly.
You know?
So, and you had it. You had it. It was
Yeah.
right there. You could have gotten it, but you chose not to, right? And
Why? So you could go to court later and lie about it. That's why.
exactly.
You know?
And you're talking about, in that instance, you're talking about things that are obviously in their possession and super relevant. So of course it should be disclosed. I think that in other circumstances it should hold true as well. One thing that I love is just private citizen cameras. An altercation that happens outside of a club, something like that, clubs, restaurants, in this day and age, they're all equipped with cameras.
Yeah.
You know, why did anyone go and ask whether the cameras were operational, they were seized, etc.? And I know you've said that sometimes you like to request disclosure late, etc. I take a different approach, specifically with regards to these cameras, because one thing they can hide behind is if you order that late, they can say the retention period is lost. The retention period was, let's say, for 6 months.
Yeah.
And you waited a year to request that disclosure. Well, it's gone, right? In that instance, while you could still make the argument, well, they should have done their investigative duties and gone after it, more often than not, you don't really have much of a leg to stand on. Which brings me to my next point. I don't think that defense counsel should sit idle and just wait for disclosure to come to them, or even only ask for disclosure from the Crown, right?
What do you mean by that?
Go and seek things out, right? What I like to do is, if I know, obviously, the geographical location of an offense that's taken place, if there's a fight outside of a bar and I talk, the best source of information in any case is going to be your client.
Yeah.
Right? If you have a good relationship with your client, you have that proper solicitor-client relationship, the first thing you tell your client is, listen, at any point, if you're lying to me, I can't help you.
Yeah.
If you're lying to your lawyer, you're your own worst enemy.
Absolutely.
And if my client is telling me something that's so different than what the police are saying happened, then I'm going to go to the establishment myself. I'm going to introduce myself as defense counsel. I'm going to ensure that they understand they don't have an obligation to talk to me or give me anything.
Yeah.
And more often than not, the person, like, let's say I speak to a security manager or a manager at a restaurant, bar, or whatever the case is, they comply. They speak to you. Dude, do you have cameras? That's all I want to know.
Yeah.
And I tell them, listen, you're not obligated to speak to me. You're not obligated to disclose anything to me or to give it to me. But I can save you a lot of trouble and hassle if you just give me the information that I need so that I can make an assessment as to whether I want to subpoena these things.
Yeah.
Right?
Absolutely.
Do I need to come back with a piece of paper and a judge that says, tell me what I need? Or you can just tell me, do you have security cameras? If yes, what do they capture? And if they're relevant in my view, what's their retention period? And then if they exist, no problem. You don't have to give them to me. Then I'll go to a judge and get that subpoena and come back to get that disclosure.
Yeah.
So it goes a long way for you to do your own investigation. And in the process of doing that, in basically developing this disclosure effectively, you're helping your own case in other ways. Because then, for example, let's say this person says, I got into a brawl. These people all jumped me at the entranceway of this club. And you go, and the entranceway is this tiny little cubicle, right, where two people can barely fit.
Yeah.
Then what comes of that is that you think to yourself, how did you get jumped by 8 people in a tiny cubicle where only 2 people
Yeah. Then
can
you show
fit?
up with your own pictures, right?
Exactly.
And you say, sir, this is the cubicle where you jump by 8 people.
Yep,
You know?
exactly. And yeah.
Yeah.
Even in front of a jury, like, you can bring what's called a view application, which is just pretty much putting to them, this is what this looks like, for example.
Oh, you mean like taking them on a field trip to go see
Basically,
it?
yeah.
Yeah, right. Good luck trying to get that application.
I know, that's a really tough one.
Those, unless you're representing Paul Bernardo and the Crown applies for it, you're not getting that. I'll tell you that much.
Yeah.
For sure. But yeah, man, no, you're absolutely right. And I find that's one of the most fun parts of the job is doing stuff like that.
Yeah.
you know, and you'd be surprised how often people like, you know, they do want to help you, right?
For sure.
You know, and like they just want to talk about something that's happened, right? Like
For sure.
It's crazy. Like,
Yeah.
you know,
Even in the process of doing that, one time I was bringing a lost evidence application. It was like clear as day. I literally went outside, and with my phone camera, I took pictures of the perimeter of the building, and I took photographs of every single camera bubble around the perimeter of the building that it showed. No matter what and no matter where this shit happened, the police said it happened in the parking lot. One of these cameras would have captured it. Mm-hmm. And in the process of doing that, basically what had happened was the cops on the night of the incident had gone, and they said they spoke to employees there. It was like 3 a.m. They asked for security footage, and they said, no, you got to speak to a manager, a security manager, in order to retrieve that. And then they just dropped the ball.
that's even worse than not looking for it at all.
Basically, yeah.
You can play dumb and be like, I don't know the camera.
Exactly. And, you know, one guy just went and spoke to someone, never tasked anybody else to go and do it. Another guy spoke to someone else that same night and then went off on vacation for like a month. You know, so they never did any of it. And then through doing that, and by the process of speaking to the manager there, I asked him, I said, do you recall the events of that night? And he said, yeah, I was actually doing an event here. And I said, do you remember that night? He's like, yeah. I was like, did any officer come to speak to you? He's like, no.
That's nuts.
And I had him
What
come and testify too.
man?
Yeah,
Yeah.
exactly.
You know?
You're just making shit up in your memo book notes,
yeah.
basically.
Honestly. And I feel like, you know, this is like, it comes kind of, I don't know what goes on in the minds of, it's not normally the Crown. Crowns, I find, for the most part, are very honest. Mm-hmm. And they have too good of a gig to fuck it up by trying to hide something.
Yeah, that's very
right.
rare.
That's super rare. I don't think it's
Yeah.
ever happened to me. And even Crowns I dislike to work with, people who I think are bad, stupid, whatever the case may be, I don't think any of them would ever intentionally hide disclosure. But
No.
the police, on the other hand, I think that they would.
That's
I just get that feeling. It's never happened to me, but like, there have been situations in the past where I get some really, really important stuff, like midway through, or the morning of the trial, that I have been asking for and has been an issue from day one of the case.
Yes.
Right? And I'm like, yo, how the fuck does this happen?
Yeah.
It's because the Crown found out about it, and the Crown probably told the cops, yo, you can't do that.
Yeah.
Send that over here right now.
Yeah.
You're going to screw everything for everyone.
Yeah.
Including in that same case that I had where they used a shotgun to blow the guy's door open. Mm-hmm. In that case, one of my main arguments is like they did something called like an operational plan where they have the suspect's face, they have information about the suspect, what his record is, his threat level, and they give it to everyone so they can have an idea of who the person that they're going to arrest is. Mm-hmm. And it shows the amount of kids, where he lives, all that kind of stuff. In this document, it showed that there were 2 children who may be in the house. There was no surveillance or anything conducted at all.
Right.
I get that shit the beginning of the trial. Yeah. I'm like, this is already a problem here.
Yep.
And then I'm in the middle of me kind of examination in chief of this one officer. He was the head of the kind of team or whatever. That ends up being a radio communication recording where somebody asks him, if there are kids home, do we change our plan at all? And he's like, no, our plan doesn't change, whether there are kids home or not.
Yep, at least he's being honest.
Yeah, I'm like, where was that recording months ago when I requested it? You know, you knew this was a problem. That smelled like to me that they're trying to hide something. Mm-hmm. But the Crown was like, yo, if I get caught hiding this, my career is basically done. You know, so that's why I ended up getting it.
I'd say the vast majority of them are not interested in anything like that.
No, I don't think so either.
Yeah.
This is just a very select circumstance. I mean, people always feel like something's being hidden from them.
Yeah.
But, you know, I think it's called Hanlon's razor. Don't attribute to malice what can be explained by stupidity.
Absolutely.
and most of the time, they're just lazy and stupid. It's not that they're trying to do something to screw you.
Yeah.
At least if there's something wrong, a lot of them do their job great. Right? Some of them are smart.
And, you know, you got to discount some of it to the fact that I think all good criminal defense lawyers have to have a very healthy level of cynicism. You wouldn't
yeah.
be good at your job if you didn't, you know.
Yeah, if
And
I
so-
trusted everyone that came my way, man, are you kidding me?
Exactly. And I think
I'd be living on the street.
that cuts both ways too. You know? It's
Yeah.
not just about the opposition. It might be
Yo, even my own colleagues. You think
Yeah.
a lot of criminal defense lawyers aren't sleazy pieces of shit too?
for sure, yeah.
We're stupid. There's tons.
So I think to that end, you know, sometimes even like mid-trial, I've received notes after I filed my charter. I've received notes of an officer that I had no idea had anything to do with anything in this case. You know, giving rights to counsel to my client
Yeah.
all of a sudden. You know, like
All of a
where
sudden,
did this come from?
here's the list that shows that she called her lawyer 5 times.
Exactly. And you know, it's amazing because I asked the officer one time, because they give these like printouts of when like they call duty counsel. And I asked the officer in charge, I'm like, if one officer puts something or there's nothing in there, can that be changed? And he's like, no, it can't be. So then I probe further and I realized that when he says no, it can't be, he means that 2 officers can't simultaneously be in the same system at the same time. In other words, if an officer puts something and says or omits to put that duty counsel was called, once he's out of the system, another officer can absolutely go back to the system and make that change.
Oh, so that's the way he
That's the
answered?
way he interpreted
that. Is
that,
a
yeah.
fucking really misleading answer to
Exactly.
the question. Everyone knew that's not. I wasn't asking that question.
So, you know, when these things started to happen to me a few times in the middle of my trial, I started to change the way that I request disclosure. Now what I do is that I don't just say, give me this. And if they say, no, we don't have it or whatever the case is, I pin them down to say, confirm that what I'm asking for doesn't exist.
Yeah.
You know?
And if what I'm requesting doesn't exist, please note that in writing that this doesn't exist.
Of course.
Or if you're not providing it, you tell me why you're not
Exactly.
providing it, you know?
And I think that's with disclosure, that's it's important. And it's something that you gain with experience. That comes about.
All right, so I think that covers all of the basic. I mean, you can talk forever about disclosure, and we'll probably get into it in more detail when we talk about some other types of cases that we do. But that's a gist of it. And remember, you know, anytime you hire a lawyer, now you're equipped with the knowledge of knowing what disclosure is and what your lawyer's job is, and you kind of have a bit more of an idea now of what, you know, you pay your lawyer to do. Right? This is a large part of what you pay your lawyer to do.
100%.
Is get this part of the process right. You know, people think you just read the paperwork and that's it. Nah, you know, it's like there's a really, like a shitty lawyer who doesn't review the disclosure has no chance at doing as good of a job as a lawyer that is diligent.
And early.
Yeah.
Yeah, you know, and I think the sentiment of the criminal justice system is supposed to be that it should be readily accessible and available so that self-represented individuals should be able to navigate the system and be able to get what they need to represent themselves. Honestly, I hate to say that nothing could be farther from the truth. It's nonsense. And obviously we know that access to justice is a huge problem. There's a massive gap between the number of people who qualify for legal aid and those who can actually afford to pay a lawyer privately. There's so many people in the middle ground there.
If you
right?
make more than like $12,000 a year,
Yeah,
you're representing yourself, basically, you know, like.
So, I mean, that's when good, proper representation could really make or break your case for you.
Yeah. All right. So until next time, thanks everyone for listening and tuning in. If you have any questions, don't be afraid to drop us a line at Titan LLP on Instagram, what's our website? TitanDefense.com.
It's TitanLLP.com.
TitanLLP.com. Yeah. Or, you know, shoot us an email, text messages. We're both very accessible all the time. Happy to have a chat with anyone whenever they want.
For sure. Would love to discuss any issues you have with disclosure, give you our advice or opinion if you give us a call.
All right. Thanks, everyone. Peace.
Later.